Bet I'm live, brother. Well, not really live. I'm pre-recording this, but I've been going on and on. Wanting to comment on some of the various issues that have been going on in popular culture. Every time I think of pop culture, I keep forgetting it. It's like an abbreviation for popular culture. I think of little tweens, racially ambiguous tweens dancing and shit. But anyway, I am Issa Israel. I'm sitting at the helm of a family of small companies, largely aimed at providing professional consulting services across a range of industries. Not only do I consult, though, I provide the services proper to the general public. So I don't just help other people provide services, but I also provide certain services myself. Much of my focus lately has been on Consultants Legal Limited, DBA, Issa Israel law firm. Much of my work under my Issa Israel law firm helm, it's targeted on business law issues. Specifically contractual disputes, a lot of administrative law issues, I do some criminal, but increasingly I've been focusing more on entertainment law, be that some of the contractual challenges common in entertainment law, but also trademarking, intellectual property issues. Far too often we create brands, we give the brands away. We give our IP away or we leave it exposed. So one thing that I do is I help entrepreneurs protect themselves. I help entrepreneurs not just set up their businesses and structure them and brainstorm for better ideas and better approaches, but also help individuals protect the intellectual property that they've given birth to pursuant to those business ventures. A lot of times this is something as simple as just filing a trademark registration. So that's one area that I've been pursuing wholeheartedly. A passion of mine is combat sports, so I've also been gearing much of my services towards professional athletes and combat sports athletes, be they MMA fighters or boxers or what have you. Kickboxers, the whole nine. Come one, come all. Anyway, here today to talk about the Joe Budden situation involving the separation of his co-hosts. So I've been hearing a lot of people talk about this notion that Joe Budden didn't have the right to tell Rory, not to record on a particular day. So let's just start there. The relationship between two people, the relationship between two parties, I'll actually say. When we want to define the scope, figure out what's going on, figure out the parameters, the limitations, whatever the case may be, this is something that you can't really do unless you actually read the contract. This notion that because Rory was there from the beginning, that they're on equal footing or to some degree is nonsensical. Doesn't matter. Okay, there are Fortune 500 CEOs who had the same secretary for 30 years. I worked for a once thriving practice in Florida where our founder, he literally founded his firm in the basement of the office manager. Now, she was treated quite well, but the fact remains that nobody would sort of make the claim that she was a part owner of that law firm. Matter of fact, at the time, that wasn't even a possibility. One of the arguments that I've heard in defense of this notion that Rory, or perhaps even to a lesser extent Mal, that these guys are not employees, is this idea that they are profit partners. Now, look, I'm not the oldest attorney, but I've been around the block a few times, and I can tell you this: the term in and of itself, profit partners, it's not a term that I hear a lot in my contractual law and business dispute dealings. I just don't hear it a lot. So let's start with this. First of all, to say that you're not an employee when you are an independent contractor, it's almost illusory. It's like it's not, you're saying something, but you're not really saying anything. In law, especially administrative law, sometimes the distinction between an independent contractor and a W-2 employee is so thin that it's set aside. Let's say, for example, there are cases in which somebody wants to file a claim or an action, and the issue, matter of fact, let's just say it's an unemployment claim. And the issue of whether or not they are an employee or they were an employee gets raised. Well, there's a test that the courts apply. There might be some variation between states in terms of the specific elements of the test, but by and large, courts are going to be looking at the end of the day, when you walk through these doors, who controls what you do? And again, the actual test has about 5 or 6 prongs, if I recall correctly. But I would say, just to kind of simplify it, at the end of the day, we're looking at who controls what you do, when you do it, how you do it, sort of thing. And I would say, for the most part, when you fail that test, well, depending on the outcome of that test, right, you could be determined to be an employee. So let's just start there. Being an independent contractor in and of itself doesn't necessarily mean that you're not an employee under the law. Let's set the law aside, though, and just look at, just from a layman's perspective. Regardless of what the law says, whether or not you are an employee or an independent contractor, it almost doesn't matter, particularly in the context of this contractual dispute and whether or not Joe Budden had a right to tell Rory not to record that day. It's actually irrelevant. It's entirely irrelevant whether or not they're independent contractors or employees. So let's just establish that. Moving beyond that, examining this notion of whether or not they are profit partners or partners. Well, let's drop the profit, because like I said, it's not particularly a common term based on my experience. But in terms of them being profit partners in general, listen, I once did a deal with a company. They're a dispensary. I did this as a business consultant. I don't think I was even practicing law at the time, but here's the bottom line. We had an arrangement where, so they were having licensing issues, the enforcement. I'm here in Colorado, and in Colorado here, there's a very robust enforcement, both at the municipal level, at the state level, and then, of course, certainly in the early days, there was always the federal government looming over your head, and just, I think what their main concern was, and this was communicated in some of the information, and I think it was a directive that they had released, the AG's office had released, but one of their concerns was to make sure that the entities out here operating in the marijuana industry, that those entities were not affiliated with organized crime. So once that was the case, you kind of just had to deal with the municipal and state level in terms of the regulatory bodies. Anyway, so I had a client, very aggressive business guys. They're from Asia. They came out here, and largely they did what they wanted. They would get these letters from the enforcement bodies, and they didn't really comply. American bureaucracy is a it takes some getting used to, right? So when you come from another part of the world, you've been here for a few years, I think sometimes they don't really recognize how robust, Big Brother is here. Let's just say how robust, the regulatory approach is here. It's almost like it's almost mafioso in essence, that this notion that there they are hovering over you, controlling what you do. Anyway, there are obvious advantages to regulation, particularly in certain industries. But in marijuana, this particular client really struggled to stay afloat. They were constantly being cited. They were receiving these notices of violations and what have you. So I ended up stepping in as a business consultant. And what my job was to keep their licensing issues, keep their relationship with the regulators smooth, resolve licensing issues, be proactive in my approach in terms of preventing licensing issues from even arising. In exchange for that, I received, I don't recall what the exact percentage was, but let's just say for the purposes of this conversation, 2.5% of the profit. Now, one thing I quickly learned is getting a percent of the profit can be a really tricky thing. A really tricky thing, right? Particularly when you don't control, you have no approval over the expenses, right? Let's just say hypothetically, here I am, my little brother's a tech guy, okay? Let's say I've got a deal and somebody's getting 5% of my profit, 5% of the profit that I derive from my business consultancy. Well, what do? I wouldn't do this, right? But just saying, in terms of the legal loophole that exists, what do? Well, okay, you know what? I've been having tech issues as of late. I'm gonna bring my little brother on. He's a sharp guy. I think he's worth $180,000 a year. Boom. You see what I'm saying? So all it takes, if you make the decisions when it comes to the expenses, and as you know, everyone, this term of sitting behind the expenses, I guess, is what we're hearing. So if you're sitting behind the expenses and you're supposed to be receiving a percentage of profit, then it's kind of tricky, because you can really end up receiving nothing, because at the end of the day, you don't control how much profit there is, because even profit that probably could exist at a certain level, you may not ever get there, because there could always be additional expenses. Now, so that's just an objective sort of analysis, but I'll tell you this. On the other hand, look at this. And I also do mediation. So I can tell you this. I tend to sometimes look for harmony between differing perspectives. I look for harmony. So in the case of this, let's just imagine now if you're Rory and Mal, okay? And again, this is not suggesting that Joe Budden has done anything untoward, shady at all, right? But just think about it objectively. If the structure of your compensation, right, involves a percentage of profit, it's natural for you to be extremely skeptical about every expense. It doesn't matter if Joe Budden was the most forthright, fair, even going above and beyond sort of, business leader or whatever, right? It doesn't matter. It's natural for people who receive a percentage of profit to be super skeptical about the expenses. So from that perspective, I would say this, if you're the general public, drawing conclusions about this issue, or let's just say, if you're Joe Budden himself, right? You've got to go into this deal recognizing that these guys are going to be skeptical. Not only are they going to be skeptical, right? But it is to be expected. It's human nature. It is to be expected. Now, I've done business with friends before, and I think that maturity requires you to go into a situation recognizing who has the power. Even when you do sort of step into that scenario with that understanding, however, time has a way of changing things. So let's just say you're Rory and Mal 7 years ago. You're super excited for the opportunity. You're super appreciative. As money begins to come in, you're like, wow, this is the opportunity of a lifetime. Well, what happens over the course of 3, 4, 5, 6, 7 years is people become more ambitious. People want more. To use Joe Budden's word, people begin to experience a sense of entitlement. So I would say this is a scenario where you could understand both people's perspectives. But to get back to the original point of this, the original focus is that Rory and Mal, they're not partners. They just have a unique payment structure that entitles them to be compensated based on a percentage of what Joe himself actually profits from the pot. This is not a scenario in which they're getting a percentage of revenue, which is one way that people, arguably a better way to structure this, right? You get a percentage of revenue, And then the expenses have to be approved you've got to figure that one out, right? In terms of who's going to be a point person on that. Maybe they have some voting rights, and maybe those voting rights, let's just say Rory and Mal combined have 25% voting power on accounting issues. Let's say Joe has 50%. Let's say an approved accounting firm has the other 25%, and you can come together and you can make decisions, sort of in a council type of way. You can vote on it, and at least they have a chance of prevailing or producing a deadlock. So let's say maybe Joel should have less than 50 so we don't end up with a deadlock. But anyway, the point I'm making is there has to be a solution in terms of these expenses, that would allow Rory and Mal to be able to make sure that they see their percentage of the profit. But at the end of the day, they're not splitting revenues. I would go so far as to say they don't have equity in the company. Now, you could argue, look, if you're getting a percentage of profit, hey, look, you've got equity. But hey, here again, we've got to see what the contract says, right? If the contract says, as long as you are employed here, you get a percentage of the profit, and ultimately Joe has the say as to whether or not you're employed here, then essentially you don't have equity. Again, it's just a unique payment structure. Unique in air quotes, right? So yeah, it's just a unique payment structure. So there's so many different ways they could have done about that. There's so many different ways that they could have, so many different things they could have done to kind of make that deal, to preserve the essence of the deal, but to make it work a little better functionally, and like I said, maybe having some say or some input over accounting expenses could be one. Oversight at a minimum, having an opportunity to be able to critique expenses, these kinds of things. What I ended up doing after that experience that I had with the dispensary, though, because I didn't really get compensated the way I should have been either, but what I ended up doing moving forward was to create a minimum. So let's say I look at the last 3 years of revenues, and maybe I say, look, I'm entitled to 2.5% of profit or $1,500 a month, whichever is greater. Do you see what I'm saying? You could obviously go the other direction as well, but the bottom line is that if you create that floor, if you introduce that floor, then now you can say that, okay, I can have a solution here. I've got a solution where at least I know I'm getting X, Y, Z. Another way is to maybe structure it in terms of a draw. A draw might not be as impactful as introducing the floor. And maybe you could find a way to combine them both. There are ways to do that as well. But just to explain that, what a draw would involve is, let's say, same deal. Let's say Rory and Mal combined are entitled to 5% of the profit from the Joe Budden podcast. Well, a draw might say, separate from that or sort of, related to that, Rory and Mal are entitled to a draw of, let's say, $6,000 per month each. So no matter what the profits are, these guys are entitled to $6,000 a month. And what you do is, at the end of the quarter, or at the end of the year, or whatever you want to do, I would say that the quarter, doing it per quarter would make the most sense. But at the end of the quarter, you end up comparing what you received in the draw. So if it's $6,000 a month each, then we're talking $18,000 each, right? $36,000 total. So we look at that $36,000 total at the quarter, and we compare it with the hypothetically the 5% of Joe's profit, right? And we say, okay, well, the 5% of the profit was actually $50,000. So now I've got to cut a check for an additional $14,000, $7,000 each, presumably. And again, what that does is it gives them some security. I heard them speak, and I heard both sides speak, and much of what was said had to do with, look, these guys got obligations, they've got life decisions to make, so they can't really be in a situation here in which they have no idea what they're going to make every month, perhaps, or maybe every quarter. They're squabbling and arguing over expenses. Well, with the draw, you may still end up arguing over expenses, no doubt, right? But at least you are in a position, you're basically in a more stable financial position where you know what's coming in sort of at a minimum, arguably. Settling it up can be tricky, but if you got an entity with some real backing, then maybe you come up with a general approach to settle up. So when I say settle up, let's say, for example, if the 5% of the profit is less than $36,000, then maybe you don't say, you know what, okay, we're going to just eliminate your draw for the next 2 months. No, maybe we say we're going to reduce your draw by 10%. Until we settle up, right, or until we get to the next quarter, or maybe we do no settling up, right, unless we end up in the negative for 2, 3, or even 4 quarters consecutively. So there's a lot of different ways to go about it. But bottom line is, stop saying that Joe overstepped. Let's start there. He did not overstep. The notion that he doesn't have the power to tell Rory not to record is preposterous. It's laughable on his face. I mean, I don't want to get racial yet. But I'll tell you this much. If the shoe were on the other foot, I highly, highly doubt Joe Budden would be getting any criticism. Highly doubt it. And at the end of the day, Rory and Mal, do I know these guys? No, but I will say objectively, I would imagine that Joe had other options, maybe comedians, mid-level B tier comedians, even C tier, right? It could have been he could have grabbed some of his homies who maybe would be considered eye candy for ladies, but no, he dealt with, and again, I don't want to get shallow here, but I don't know these guys, whatever, but no offense, but he dealt with some really mediocre guys almost across the board. And I don't mean that as an insult, right? I'm just saying from a business perspective, right? You might imagine that if you're going to produce, a podcast, right? Like, my little brother gets mad when I say this. My little brother is super good looking, So, okay, if I have a podcast, and then I want to get his pretty ass on camera, because maybe I get some subscribers based solely on that. No, but seriously though, also, personality, humor, these things matter as well. And while there certainly is a synergy to be spoken of when you're recording a podcast with friends, it's arguably not as effective as people who are trained to communicate in a way that makes people laugh, etc. So, bottom line is, he gave them an extraordinary opportunity. They probably should appreciate that a bit more and probably not feel entitled or empowered to the extent that this man can't make ultimate decisions about the direction of his podcast. That said, Joe Budden needs to properly and effectively communicate what's going on. Sometimes it's not totally what's in a contract. I can tell you from the perspective of a contract attorney that sometimes when we're examining deals, sometimes let's say if a court is examining a deal, the court may end up looking at, along with other factors, they may look at the relative power of each party. Okay, just to give you an example. Let's say me as an attorney. Let's say I enter into an agreement with a client of mine who owns a plumbing business, and my job is to handle some back office issues in exchange for 50% of his company. And on the record we can see that what I've done is I've responded to a couple complaints by some people whose homes may have been damaged as a result of what they believed was a faulty job. But other than that, I'm essentially doing nothing. I'm just fielding mail, maybe setting up websites, editing, whatever. I don't know, whatever. A court may look at that and say that deal is unconscionable on its face. I'm really not entitled to 50%, right? Because there's maybe there may not be much of a power disparity between myself and a plumber client, right? But there are disparities in other ways. They may say that, well, he lacked the sophistication, we weren't on equal footing. But the same thing happens sometimes when you're dealing with a large entity versus a smaller one. And you could argue that Rory and Mal they lacked the power to effectively negotiate, and that the deal that they received, a percentage of profit, that deal was unconscionable, particularly given and assuming that this information you communicated was accurate, but assuming that they had no right to receive the accounting. That's one of the claims that he made, to my knowledge, was that he doesn't have to show the accounting. And there was some information that was almost conflicting on that, So, I mean, bottom line is that if you have a deal to receive a percentage of profit, and you have a caveat in the contract saying that they're not entitled to see accounting, much less approve it, then I would argue that deal probably wouldn't even stand. At least that particular provision of their inability to see accounting, that could be a problem, because it's so heavily slanted in the way of Joe Budden or the Joe Budden podcast, that the payment structure itself, it could be stricken. So anyway, I've rambled on about this enough. If you have any questions or comments, please comment below. This is, I think I've set up a few different channels before, and for various reasons, some of them were related to perhaps employment and other projects. But right now, I'm completely independent, so I'm going to be talking about a lot of different issues. We're going to be talking about business issues, legal issues, also just some regular life stuff that I think is very important and honestly fundamental to being successful in business and in life. Issa Israel here, check it out. The name of my company is Consultus Global, and Consultus Global, that is, I use that name to describe the family of companies that all fall under the Consultus Global banner or brand. We'll get into that a bit later, but for now I want to focus more so on other people and just analyzing these issues and seeing what lessons we can take and apply to our own lives to enrich them further. Peace.